Welcome back to the Friday Five for June 30th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney. Let's look at 5 quick questions in 5 minutes and get you out of here for hopefully a great holiday weekend. Question number 1 this week. Can I move an investment into a trust? Simple answer to this is yes, you can. But what you want to do is make sure you talk to the person who holds the investment, the company you're investing with, and make sure they are okay with your ownership interest being held in a trust. Most of the time, it will be not a problem and it will not be a taxable consequence. It won't be a taxable event for you to deal with. However, you want to make sure you've talked to the investment company and that they can process that transaction for you. Question number 2 this week. What happens if I'm sued after the statute of limitations has expired? So this came up with a client who called because they'd been sued in another state long after the statute of limitations had expired on that debt. They're a bit concerned because, first of all, there shouldn't be a lawsuit, and second of all, it's so much later. And so the question was, what do they do with the statute of limitations defense? And the simple answer is you can tell the court that there is a statute of limitations problem and that the case should be dismissed. In this case, the debt was relatively small, however, and so what the client has to deal with, and what most clients have to deal with, is the economic realities of the situation. So if, in this case, the debt is $1,000 and it's going to cost you $5,000 for an attorney to appear and make the case go away to get it dismissed, you want to consider the economics of both of those paths and decide which one is the best for you going forward. Question 3, how do I calculate damages for my breach of contract case? This came up in a call with a prospective client who was very nice and was going through a few things, and there had been a breach of a contract, so that was very clear. But the problem is you need to look at the second part of a breach of contract case, and that is, what are your damages? So in this case, the other party had breached the contract, but the other party also had not required this person to pay the money that was due under the contract. So there had been a lot of back and forth, and the wrong thing was provided. There was no payment in the end, and the question's going to be, what is the damages that this person has suffered under the breach of contract? So just because somebody breaches the contract doesn't mean you're entitled to a lot of money unless there's a liquidated damages clause that says if someone breaches, you're entitled to $50,000. But without a liquidated damages clause, you need to make sure you understand not only if there's been a breach, but also what the amount of damages will be if there has been a breach of that contract. Question number 4, which comes up quite often, does my second wife get my house if I die first? I had an interesting consultation with clients who, they were the children of the father. And the father, as their mother has died, their father has remarried. He's remarried someone a little bit younger who has children of her own. And the question is, the house they live in is owned by the father and the stepmother together. And what happens if the father dies first? And the simple answer is that the house would then go to the stepmother. She owns the house because she's on the title with the father. And there's no requirement then that the stepmother gives anything from the house or distributes the house or distributes anything to the father's family from his first marriage. So in situations like this is one of those important answers we have to give to a blended family, which is, people usually have children from a prior relationship, get married again, either after a divorce or after somebody's died. And if we want to create an estate plan that protects not only the father's children from the prior marriage, but also stepmom's children from a prior marriage, we can use a trust to make sure that the assets are properly distributed to everybody involved, and we keep those assets in the family for each of your children. Question number 5 this week, do I need to sign my will first or do I sign my trust first? So this is going to be a state-specific question, but in most states, and the states where I practice, you need to make sure that you actually sign the trust first, and then after that you sign what we call a pour-over will. And what the pour-over will do is take any assets in your name at the time of your death and move them into that trust. And if you're creating a separate revocable living trust or an irrevocable living trust and you're setting it up now, you want to make sure you're also funding that trust. So we want to make sure that trust is set up and in place before you sign the will. So this came up because a client was attempting to sign the will on their own, and they signed the trust as well, and they accidentally signed them in reverse. So we've got to go back and get that cleaned up. So there are your 5 questions in 5 minutes on the Friday. It's June 30th, 2023. We're coming up on the long holiday weekend here in the United States. So if you like this video, you can hit the thumbs up or the like button below. There's a link in the description for you to ask questions for future episodes. Wherever you are, I hope you have a wonderful weekend, and we'll see you back here next week.